Hey everyone, Rob Ryder. What the heck day of the week is it here? Today is Tuesday, February 7th, 2012. Again, from the commentaries on the Laws of England by William Blackstone, Book 3, Chapter 25 of Proceedings in the Nature of Appeals. As all civil matters can be appealed, this may be good to know how this works. Let's find out. Proceedings in the nature of appeals from the proceedings of the King's Courts of Law are of various kinds according to the subject matter in which they are concerned. There are principally three. Well, I would say there's three because, well, let's find out why there's principally three. You have a writ of attaint, which lies to inquire whether a jury of 12 men gave a false verdict, that so the judgment following thereupon may be reversed, and this must be brought forth in the lifetime of him for whom the verdict was given, and of two at least of the jurors who gave it. Okay. Uh, this lay at the common law only upon verdicts and actions for such personal injuries as did not amount to trespass. So, if they didn't amount to trespass, then they could be appealed this way. For in real wrongs, the property injured had redress by writ of right, but after verdict against him in personal suits, he had no other remedy, and it did not lie in the action of trespass, for a very extraordinary reason, because if the verdict was set aside, the king would lose his fine. For in real wrongs, the party injured had no redress by writ of right. Okay, for real wrongs, not personal wrongs. But after verdict against him in personal suits, he had no other remedy. But by a statute, it was given that all pleas of land, franchise, or freehold, and by several subsequent statutes, we just keep adding statutes, right? It is allowed in almost every action except in writ of right. For there no attaint lay, either by common law or statute, because it was determined by the grand assize consisting of 16 jurors. So you're going to find out that a true jury, grand jury, has 24. Should have 24, and I don't think it can have less than 16, but it should have 24. The jury who are to try this false verdict must be 24. There you go. And called the grand jury. For the law wills not that the oath of one jury of 12 should be attainted, stained, or set aside by an equal number, nor by less indeed than double the former. And he that brings the attaint can give no other evidence to the grand jury than was originally given to the petite. For as their verdict is now trying, and the question is whether or no they did right upon the evidence that appeared to them, the law judged it the highest absurdity to produce any subsequent proof upon such trial, and to condemn the prior jurisdiction for not believing evidence which they never knew. But for those against whom it was brought, as are allowed, in affirmance of the first verdict to produce new matter, because a petite jury may have formed their verdict upon evidence of their own knowledge, which never appeared in court, and because very terrible was the judgment which the common law inflicted upon them if the grand jury found the verdict a false one. But those against whom it is brought are allowed, in affirmance of the first verdict, to produce new matter. Okay, so they're going to have to affirm the first one with new matter, which is to bring forth evidence that wasn't in the case in the first time. That's what it sounds like there. Affirmance is the confirmation, ratification, confirmation of avoidable act. This statute and affirmance of the common law. So affirmance means confirmation of avoidable act. Well, if it can be avoided, that means you can avoid it. I don't know how to do that, but that's what it says. So, anyways, at one time, if there should be this case where the judgment was that these are the things that would happen to the jurors, that their wives and children should be thrown out of doors, that their houses should be razed and thrown down, that their trees should be rooted up. It wasn't good to be on a jury and give a false verdict. But because it was pretty severe, they decided to lessen it. And now, more moderate punishment is inflicted upon attainted jurors, viz., perpetual infamy. In the case of an action above 40 shillings of value, a forfeiture of 20 apiece for the jurors. Infamy is the state in which produced by the commission of a crime and the loss of honor. So basically, it's criminal. I mean, this would be common law criminal. So that a man may now bring an attaint either upon the statute or the common law at his election, and in both of them may reverse the former judgment. But the practice of setting aside verdicts upon motion and granting new trials has so superseded the use of both sorts of attaints that I have not observed any instance of an attaint in our books later than the 16th century. So again, all he's saying is it's available to be used. It hasn't been used since the 16th century. They've gotten us to do motions and granting of new trials, all these other things, instead of an attaint to the jury. Now, I don't know how you would do that, but right, that appears to be a way. By the old Gothic Constitution, indeed, no certificate of a judge was allowed in matters of evidence to countervail the oath of the jury. But their verdict, however erroneous, was absolutely final and conclusive. The witness of the judge and of his acts, but the judge cannot attest to them in turn, whether correctly or they will swear falsely for any kind of assertion to be held by the judge. Yet they had proceeded from whence our taint may be derived, if upon a lawful trial before a superior tribunal they were found to have given false verdict, they were fined and rendered infamous for the future. It's a little more Latin here. So, if, however, an evident proof or false juress convicted, the judgment to know what should be, in good find the rest of perjured and infamous. Okay. Well, anyways, that's one way. Next one is called a heard complaint, and where the defendant against whom judgment is recovered, and who is therefore in danger of execution, or perhaps actually in execution, may be relieved upon good matter of discharge, which has happened since the judgment. And here is to perceive sound by ear. So I think you have to say it out loud, or you have to do it on a common law deed because that is a living document, um, in my opinion. So this would be like a plea to the crown, right? Written down. It's really a plea to the crown. You could do that verbally, or you could put it on paper. As if the plaintiff had given him a general release, or the defendant had paid the debt to the plaintiff without entering satisfaction on the record. So, if these civil cases that they're trying us for are only worth $20 because they don't have an original writ sued out from Chancery under the Great Seal, they're only worth $20. We should be able to go pay that bill. Okay, you won. Here's your $20, and that should make the case go away. And they shouldn't be able to collect on the other things. In these and like cases wherein the defendant has good matter to plead, but had no opportunity of pleading it, either at the beginning of the suit or since the last adjournment, since, as was shown in former chapter, must always be before judgment, the hearing of the complaint lies in the nature of a bill in equity, to be relieved against the oppression of the plaintiff. Okay, in the nature of a bill in equity. So it sounds like they want you to put a bill into equity to do this. Um, that one needs a little more research. It is a writ directed to the court, stating that the complaint of the defendant has been heard the complaint of the defendant, and then setting out the matter of the complaint, it at length enjoins the court to call the parties before them, and having heard their allegations and proof, to cause justice to be done between them. So this sounds like if they pull you off to the side and put you in a side room, similar to what, Let's say you're out in the public court and they pull you off to the side and put you in a side room and then have somebody come in and talk to you. Right? They're trying to get you to settle in private. Um, enjoys a court to call the parties before them and having heard their allegations approved to cause. Yeah, they want you in front of the court though. Um, so not really sure. But another way it looks like it also lies for bail when a judgment is attained against them by show cause to answer the debt of their principal, and it happens afterwards that the original judgment against their principal is reversed. For here the bail, after judgment had against them, have no opportunity to plead their special matter, and therefore they shall have redress in audita querelia, which I think was the name of this thing. Yeah, heard the complaint. Which is a writ of the most remedial nature, and seems to have been invented, lest in any case there should be an oppressive defect of justice, where the party has good defense, but by ordinary forms of law had no opportunity to make it. But the indulgence now shown by the court in granting a summary relief upon motion in cases of such evident oppression is driven it quite out of practice. So again, this writ has always been there, and it would be done in common law, and it sounds like actually this is going to be done in the court of equity through the exchequer. But they get you to do this summary relief and these things in civil. They're trying to get you to take civil relief instead of taking lawful relief. But thirdly, the principal method of redress for erroneous judgment in the king's courts of record is by writ of error to some superior court of appeal. I'm going to say it's a king's bench and probate. A writ of error lies for some supposed mistake in the proceedings of a court or record. For to amend errors in a base court, and a base court's an inferior court, not of the record, that's what it is, base court, not of the record, a writ of false judgment lies. So to amend errors in a court that's not of the record, which is a civil court, a writ of false judgment lies. So a writ of error is for supposed mistakes in proceedings of a court of record, and a writ of false judgment is to amend errors in a court not of the record. The writ of error only lies upon matter of law arising upon the face of the proceeding, for that no evidence is required to substantiate or support it, and there is no method of reversing an error in the determination of the facts, but by an attaint or new trial to correct the mistake of the former verdict. So a writ of error only lies upon matter of law arising upon the face of the proceedings. Matters of law arising upon the face of the proceedings. That means something. For that no evidence is required to substantiate or support it, and there is no method of reversing an error in determination of facts. Okay, well, let's see where that brings us. Formerly, the suitors were much perplexed by writs of error brought upon very slight and trivial groundings, as misspellings and other mistakes of clerks, all of which might be amended at the common law, while all the proceedings were in paper, for they were then considered to be only, I don't know what that word is, and therefore subject to the control of the courts. But when once the record was made up, it was formally held that by the common law no amendment could be permitted. But when once the record was made up, it was formally held that by the common law, no amendment could be permitted, unless within the very term in which the judicial act so recorded was done. So we need to know what a term is in these courts. What's the length of the term? When do they start? When do they end? For during the term, the record is in the breast of the court, but afterward it is omitted of no alteration. So if they make an alteration, a date or something else after this term, that's a flaw. But now the courts are become more liberal, and where justice requires it, will allow of amendments at any time while a suit is depending, notwithstanding the record be made up and the term be part. For they at present consider the proceedings to be, to exist, to have real existence, till judgment is given, and therefore that till then they have power to permit amendments by common law. So they're saying that it has a real existence until the judgment's given. Then what happens? To me, it sounds like they say then there is no real existence. Mistakes are also effectually helped by the statutes of amendments, so called, because when the pleader perceives any slip in the form of the proceedings and acknowledges such an error, he is at liberty by those statutes to amend it, which amendment is seldom actually made, but the benefit of the act is attained by the courts overlooking the exception. But the benefit of the act is, okay, so because when a pleader perceives any slip in the form of his proceedings and acknowledges such error, he is at liberty by those statutes to amend it. Okay, moving on. These statutes are many in number, and provisions in them too minute and particular to be taken notice, otherwise than referring to the statutes themselves, by which all trifling exceptions are so thoroughly guarded against, that writs of error cannot now be maintained, but for some material mistake assigned. Material, important, momentous, more or less necessary. Well, a material error to me mistake to me would be finding an indictment that somebody else has already signed your name or there is no signature on it. Material, important, more or less energy, having influence or effect, as in where is the deed? Where's the statute merging with my signature? This is at present the general doctrine of amendments, and its rise in history are somewhat curious. In the early ages of our jurisprudence, when all pleadings were made orally, if a slip was perceived and objected to by the opposite party or the court, the pleader instantly acknowledged his error and rectified his plea, which gave occasion to the lengthened dialogue reported in our ancient yearbooks. So if the dude made a mistake and you objected, so if you don't object, you agree, then it wasn't a mistake. And you object, then it's a mistake, and the pleader can instantly acknowledges his error and rectifies his plea. So liberal were then the sentiments of the Crown as well as judges that in the Statute of Wales made by somebody, the pleading are directed to be carried out in that principality without strictness to the letter, the rigid custom not being observed, that who fails in one syllable loses the whole cause. That's the rigid custom not being observed. That's the custom, that who fails in one syllable loses the whole cause. The judgments were entered up immediately by the clerks and officers of the court, and if any misentry is made, it was rectified by the minute of the remembrance of the court itself. So, when the treaties of Britain were published in the name of authority of the king, probably 13 Edward I, because the last statute were referred to in the Winchester and Westminster II, a check seems intended to be given to an unwarrantable practices of some judges who made false entries on the rolls to cover their own misbehavior, and had taken upon them by amendment and erasures to falsify their own records. The king therefore declares that although we have granted our justices to make record of pleas pleaded before them, yet we will not that their own record shall be warranty for their wrong, nor that they may erase their rolls, nor amend them, nor record them contrary to the original enrollment. So we got an original enrollment and then something that happens afterwards, and they better match up. The whole of which taken together amounts to this, that a record surreptitiously or erroneously made up to stifle or pervert the truth should not be any sanction for error, and that a record originally made up according to the truth of the cause should not afterwards by any private erasure or amendment be altered to any sinister purpose. So we need to look at the record of the case and see if there's been any erasures or amendments after the case within or after the term. I think a term is just a week. I think there's a term that starts, every week. I'm not really sure. Okay. Just a few definitions there. So, but when afterwards King Edward, on his return from the French dominions, is the 17th year of his reign, after upwards of 3 years' absence, found it necessary or convenient to prosecute his judges for their corruption and other malpractices, the perversion of judgment, by erasing and altering records, was one of the causes assigned to the heavy punishments inflicted upon all the king's justices, even those able and upright, the severity of which proceedings seemed to have alarmed the succeeding judges, that through a fear of being said to be wrong, or said to do wrong, they hesitated at doing that which was right. That doesn't make any sense, does it? But they use that as an excuse. Um, as it is so hazardous to alter the record, even from compassionate motives, they resolved not to touch a record any more. They held that even payable errors, when enrolled, and the term at the end, were too sacred to be rectified or called in question. So they're saying after the term, the way it is. And because Britain had forbidden all criminal and clandestine alterations to make the records speak a falsity, they conceived that they might not judicially and publicly amend it to make it agreeable to truth. Well, they can't change stuff. To extract a larger fine than had been recorded by the clerk of the court below. So ask who the clerk of the court below is. But instead of amending the clerk's erroneous record, they made a second enrollment. So they didn't fix the one, they made another one. And what the justices had declared down to the mouth and left it to be settled by posterity, in which the two rolls at absolute veridity, in which of the two rolls the absolute veridity resides, whichever record is said to import in itself. Okay, well, if a record is supposed to have the truth, and you have two of them that conflict, then it sounds to me like somebody needs to take a look at it. So we need to find these original records, and it would be in the court of record. I believe that's what they're talking. These are records out of the court of record. However, to be honest, I don't know, right? But they're saying there's two sets of books. And in the reign of Richard II, there are instances of their refusing to amend the most palpable errors and misentries unless by authority of Parliament. To this real sullenness, but affected timidity, of the judges, such a narrowness of their thinking was added, that every slip, even on syllable or letter, may now be held to be fatal to the pleader and overturn his client's cause. That every slip, even of a syllable or a letter, was now held to be fatal to the pleader and overturn his client's cause. Pretty powerful. Reason to look for mistakes. If they dared not or would not set right mere formal mistakes at any time upon equitable terms and conditions, they at least should have held that trifling objections were at all times inadmissible, and that more solid exceptions in point of form came too late when the merits had been tried. They might, though, through a decent degree of tenderness, have excused themselves from amending in criminal and especially capital cases. So, what's capital? They might, through a decent degree of tenderness, have excused themselves from amending in criminal and especially capital cases. Remove false errors and correct capital, large or great size, as in capital letters. So I'm thinking that they're saying that the thing is in capital letters, it doesn't apply to you. That's an error. Writ of error. The name is incorrect. It's misspelled. That's not how I spell my name. They needed not have granted an amendment when it would work in injustice to either party, or where he could not be put in a good condition, as if his adversary had made no mistake. And if it was feared that an amendment after trial might subject the jury to an attaint, how easy was it to make waiving the attaint the condition of allowing the amendment? And that these were among the absurd reasons alleged for never suffering amendments at all. So we need to look up the word amendment as it pertains to court cases and get an idea what that means. The proceedings then set were afterwards most scrupulously followed, to the great obstruction of justice and ruin of suitors, who have formerly suffered as many of these obstinate scruples and little strictness of the courts as they could have done even by their iniquity. So they may be using this against us, right? You make a mistake of any kind, they throw out your case. After verdicts and judgment upon the merits, they were frequently reversed for slips of the pen or misspelling. The justices were perpetually entangled in a net of mere technical jargon. Well, go imagine. After verdicts and judgments upon the merits that were frequently reversed for slips of the pen or misspellings, and justice was perpetually entangled in a net of mere technical jargon. Ain't that what we're in now? The legislature was therefore forced to interpose, by no less than 12 statutes, to remedy these niceties, and its endeavors have been of late so well seconded by judges of the more liberal caste that its unseemly degree of strictness is almost entirely eradicated, and will probably in a few years be no more remembered. No more remembered that a slip of the pen, that you can use this against them. Any misspelling, slip of the pen, whatever, is a reason to have the case appealed. Okay. If a writ of error be brought after verdict, he that brings a writ, or that is plaintiff in error, must in most cases find substantial pledges of prosecution or bail, to prevent delays by frivolous pretenses to appeal, and for securing payment and costs and damages, which are now payable by the vanquished party in all except a few particular instances. So Jason and his buddy are getting this right now, right? Jason's buddy, Tony, he told him he's free to leave. He's free to go. To me, that means they can't move the case ahead. And so there's a security waiting there and damages because he's are now payable by the vanquished party in all except a few particular instances. It's owed to him. A writ of error lies from an inferior court of record in England into the King's Bench, and not into the Common Pleas. You don't appeal into the Common Pleas. You don't appeal back into civil law. Period. You go to the King's Bench. And from the King's Bench in Ireland to the King's Bench in England, it was likewise maybe brought from the Common Pleas to the King's Bench, and then from the King's Bench the cause is removable to the House of Lords. From proceedings on the law side of the Exchequer, a writ of error lies into the Court of Exchequer Chamber before the Lords. From proceedings on the law side of the Exchequer, a writ of error lies into the Court of Exchequer Chamber before the Lord Chancellor, Lord Treasurer, the judges of the courts of the King's Bench, and Common Pleas, and from thence it lies into the House of Peers. So it looks like there's two ways to do it. You got a writ of error that goes into the Court of Exchequer Chamber before the Lords, or the Treasurer, or the judges of the King's Bench, or the Common Pleas. But you got to take it to the Court of the Exchequer Chamber. Where is the Court of the Exchequer Chamber? Accept somebody's oath and find out. Ask them where it is. Use that word. That's what it's called. Cut and paste Blackstone. Take the whole chapter in. Highlight. Right here. This is what it says. This is the law. From proceedings in the King's Bench, in debt, detinue, covenant, account, case, ejectment, or trespass, originally begun therein. So this is one that not by an original writ sued out under the Great Seal, which is mainly what they do, in my opinion. They go get this writ of trespass first, and then it says, except where the king is a party. It lies in the Exchequer Chamber before the justices of the Common Pleas and barons of the Exchequer, and from thence into the House of the Lords. So, if you have, if the foundational document is something under the Privy Seal, the Court of Record, not an original writ under the Great Seal, then then you're supposed to go to the Exchequer Chamber before the Justice of Common Pleas and Barons of the Exchequer. But in all cases, I'm going to call it, in my opinion, I'm going to call it a plea of the Crown. And then that is a writ of error and what it pertains to. Whatever error you find on the paperwork. But where the proceedings in the King's Bench are commenced by original writ, suit out of Chancery, so this is if they have the original writ, big seal on it, suit out of Chancery, which must be for some forcible injury in which the king is supposed to be a party. It's the only time you're going to find it, forcible injury in which the king is supposed to be a party, in order to punish the trespass committed in a criminal manner. So that's criminal trespass. It has to have that writ. Or it has to have the original writ, suit out of Chancery, under the Great Seal. In that particular case, and only that, so if it's under an original writ, suit out of Chancery, this takes the case out of the general rule laid down by the statute. So the writ of error then lies without any intermediate stage of appeal directly to the House of Lords, the dernier resort for the ultimate decision in every civil action. Last resort or expedient. Each court of appeal, in their respective stages, may, upon hearing the matter of law in which the error is assigned, reverse or affirm the judgment of the inferior court. But none of them are final, save only the House of Peers, to whose judicial decision all other tribunals must therefore submit and conform their own. And thus, much for reversal or affirmance of judgments by writs in the nature of appeals. Okay, so you want to reverse or affirm a judgment, you do it by a writ, and it's an appeal. And I wrote this out in, looks like 19 or 12 pages. There really isn't that many different ways to do it. You got 3 different ways that we can do this, and they're all looking, for an error of one kind or another. And what we're going to find in all these civil matters is they're all going to have the same error. And when that's pointed out, that is what you use to do your appeal based on where the original document came out of, where it's going back to. So, real quick, if we go back here, right? So, if they sued out this writ from the King's Bench, which will be under the seal of the Court of Record, for debt, detinue, covenant, whatever, right? Then your writ of error lies to the Exchequer's chamber before the justices of the Common Pleas and Barons of the Exchequer. So again, I would be pulling this part out, things like this, and putting them on your document and say this is from Blackstone's commentary, Book 3, Chapter 25, authoritative book on law, used as my evidence. And let them rebut it. I don't think they're going to. Well, and then there's writ of error. So then we also have writ of error from inferior courts of record. May be brought from the Common Pleas at Westminster to the King's Bench, and then from the King's Bench for the cause is removable to the House of Lords. So from inferior courts of record and also from the Court of Common Pleas, you're going to bring them to the King's Bench. From proceedings on the law side of the Exchequer, so the law side of the Exchequer, what is that? Well, Exchequer has jurisdiction in common law, which is law, equity, natural law. And before equity can be given, it has to be lawful, because equity follows the law. First it must be lawful, then you can have equity. And this writ of error lies into the court of the exchequer chamber. So we need to find out, ask him, where is the court of exchequer's chamber? Before the Lord Chancellor, Lord Treasurer, the judges of the court of the King's Bench and common pleas. And from thence it lies to the House of Peers. Now, I know nobody's a fan of attorneys. I don't blame you. What you need to remember is there's also counselors at law that can be attorneys. They're just wearing two hats. My understanding, counselor at law, they have to be appellate qualified, which means they can hold trial in a court of record, the Supreme Court, Superior Court, whatever the case. And if you go to them as a counselor at law instead of an attorney, you're still hiring them, but they're getting hired by recompens, whatever that means. I don't think you have to pay for them. And they have the rank, if it's the same in England as I believe it is here, they're called sergeants at law. Well, that means they're an officer. Accept their oath. Bind them to it. Tell them they have a fiduciary duty to you. Do not be a concealer. Tell them you have a civil case. Take it to them. You would like a writ of error put in because you believe fraud's been done. Criminal fraud. Or that there's an error that can be overturned by a writ of error. And you would like him to find it. And submit the paperwork. See what he says. You know, I wish I had the answers on how to do this paper. Hell, I don't know, man. I don't have any court cases to go in, you know. So we're kind of going in blind doing this ourselves when we do have experts that we love to hate. But an attorney is different than a sergeant at arms or a sergeant at law. They go back and take a second oath, my understanding, right, to get the second credential. And so that's when they get taught the law. They don't get taught it when they're going through law school. They get it later. And they're the ones who can become judges. So judges know about this stuff also. So, well, that's just some ideas, people. I wanted to get that out because, you know, we have many, 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 many more cases that have already been decided, they think, than are ongoing. But all civil cases can be, appealed. And one of the main appeals in my mind is who has the superior title to the property. So if you were to bring in your owner certificate of title, also known as your certificate of live birth, as evidence that you had the superior title, then there couldn't have been a trespass in common law that started the thing in the first place. You know, it may be that simple. Show them your certificate of live birth. Say, this is my property. I got charged for trespass. How the hell did that happen? So, all right. As we learn more, we share and we learn. So, you all enjoy yourself, and I'll get this up and we'll go on to something else. We'll see ya.